Are you considering divorce? Do you and your spouse have a pension? Hi, I'm Simon de Pinaar and I'm a family attorney. Now, this is the first of 3 talks on pension sharing. It's a complicated subject, so I've broken it down into its components to make it easier to understand. Now, splitting or sharing a pension is one of the most complex aspects of a financial settlement in a divorce case, particularly for older couples. Now, outside of property, a retirement fund may be a couple's most valuable asset. Now, calculating pension interest is complex and requires expert advice to ensure the divorce order, as it refers to the pension interest claim, is actionable. Now, what exactly is a pension interest? It's a confusing term because it does not mean the same thing as interest on a savings account. Its meaning in this context is the stake one spouse has in the other's pension. Now, pension interest is the theoretical amount of the other spouse's pension. Let's call them the member spouse, because they are the member of the pension fund that the non-member spouse is entitled to on divorce. It's based on the amount of savings the member spouse has accumulated at the time of divorce. In other words, how much they have invested in the fund, combined with how much the fund has grown right up to the date of the divorce order. If both spouses are members of the retirement fund, they can claim a share of the pension interest in the other's fund. But in reality, pension interest claims are more common where the husband holds the retirement savings and the wife does not. If their marriage were to last into retirement, they would share the retirement income. Pension interest was introduced in legislation to the non-member spouse. The non-member spouse does not have to wait until the member spouse retires before they receive a share of the asset, which could be many years in the future. Now, the member spouse must be a member of the retirement fund on the actual date of divorce. If they've already retired or otherwise exited the fund, the retirement fund benefit becomes part of the divorce settlement. Now, what type of fund is eligible for pension interest? The word pension describes all approved retirement funds, as well as group pension funds, where membership of the fund is related to employment. Pension interest also applies to provident and preservation funds and retirement annuity funds held by individuals. Now, life insurance policies and living annuities are not eligible for pension interest. The matrimonial regime has a key role to play. Pension interest only applies to marriages in community of property and marriages out of community of property with accrual. All marriages out of community of property without accrual that took place after the 1st of November 1984 are automatically excluded. For couples married out of community of property without accrual before 1st of November 1984, there are some circumstances where the court may specifically grant a redistribution of assets in terms of the Divorce Act. How is the pension interest calculated? This will depend on the type of retirement fund. For pension, provident and preservation funds, pension interest equals the benefit the member spouse would have been entitled to if they terminated their membership in the fund on the date of divorce. For retirement annuities, pension interest equals the sum of the member spouse's contributions up to the date of divorce plus simple annual interest at the prescribed rate. When it comes to pension interest claims, the wording of the divorce order is critical. If the wording is not entirely correct, as set out in the Divorce Act, it may not be valid. I'll cover this in the next talk in the series. If you have any questions about pension interest, give me a call on the number in the signature below.